All
Okay.
right. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of clearing title for inherited properties and other probate concerns. My name is Nia Murray. I'm the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining our presenting partners for today, representing the Harris Central Appraisal District, we have Ms. Mabel Menifee, as well as the Harris County Tax Assessor Collector's Office, Ms. Jamie Duong, as well as our newest staff attorney with the Earl Carl Institute, Ms. Jaira Davis, who will be presenting the information for you today about inherited property and the probate concerns. We have also included the Harris County Tax Office and the Appraisal District for this presentation due to the fact that there are various exemptions or an exemption that's available for people that are inheriting property, as well as options, or what do you need to know about payment options and payment arrangements that can be made for people that have had deferred property taxes once they actually pass. So you will hear all of that information today, but also included in the partnership, we also have the Texas Legal Services Center, Houston Bar Association, Houston Volunteer Lawyers, and the Lone Star Legal Aid. And collectively, we make up a month of service. And basically what a month of service is the collaboration of all 9 of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information to the people in Houston and Harris County communities relative to asset building, asset protection, and the maintaining of generational wealth and community empowerment. We know that there are a lot of underserved communities that are out there that do not have access to a lot of information. So we decided to collaborate several years ago and come together to create a larger impact and reach more people and get as much information out to the community as we possibly can, regarding a lot of various topics, that basically can help with maintaining their generational wealth. In addition to that, this platform has allowed us the opportunity to reach people outside of the city of Houston and surrounding counties, including people throughout the state and across the country in some instances who join us live on our social media platforms to view the presentation as well. Please note that the information that does get provided in this workshop, as well as all of our other legal presentations, are for informational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like the Earl Carl Institute when you guys find yourselves in need of any civil legal assistance that you may qualify for at no charge. Also, please note that when you're asking your questions, to know that, again, we are recording the session as well as broadcasting live on our social media platforms. So we ask that you try to keep your questions to be as general as you possibly can, so that your personal detailed information is not getting out there for everybody to actually have access to. So do keep that in mind when you're asking your questions. If you are joining us on Zoom, you have the opportunity to type your question into the chat. Type your question into the chat, as well as if you are joining us on social media, on YouTube or on Facebook, please feel free to type your question into the comments section, and we'll make sure that those questions get addressed aloud at the end. If you're not comfortable with typing in the chat or in the comment section, then please feel free to unmute yourself at the end or raise your hand, and we'll have someone to call on you so that you can get your question addressed. Let's see, is there anything else that I am forgetting? I do know my camera is not on. I'm actually driving at the moment. So my face will not be seen because I am in the car and I don't want that distraction for all of you guys to actually see. So I do apologize for that today. Let's see, what else is there? Well, I guess, without further ado, we're gonna go ahead and start with our introductions as we will move on into our presentation. Ms. Mabel and Jamie, we'll have you guys go first, and you can introduce the other people from your offices who will be monitoring the chat. And then Jaira, we'll have you introduce last so that you can start the presentation first. Okay, so Miss Mabel.
All right. Thank you, Nia. Good afternoon, everyone. My name is Mabel Menifee, and I'm with the Harris Central Appraisal District. I am honored to be here today to assist with this presentation, which primarily is about clearing title on inherited property, but a lot of questions end up coming to the appraisal district in terms of exemptions and property taxes and things like that that are an integral part of that clearing title process. So I'm happy to be able to provide you with additional information about exemptions and the appraisal district. And I'm also going to be assisted today by my colleague, Frida Claiborne, who is going to be in the chat room. She is one of the folks that when you call or email in your questions about exemptions, she's going to be one of the folks that can answer those. So I'm happy to have her here with me today. And I will turn it over to Jamie.
All right. Thank you, Mabel. Thank you, everyone. Thank you so much for making the time out to here to join us on our tax workshop. You know, it's toward that end of the year, the magical time when you're gonna look for your tax statements, like you're looking for your Christmas greeting cards. We're getting those ready for you. On behalf of Ms. Ann Harris-Bennett, we want to thank you for joining us. It gives us a valuable time to share some of the new tax-related information with you. Also with me here today is Shay Pinkowski. She's one of our expert customer service agents, and so she'll be helping us on the chat room. You know, if you have questions or concerns or stuff you want to bring up to our attention, please type in the chat. We'll be happy to assist with that. Now, in today's sessions, you know, you're going to hear, you've heard a lot, so much of what's going on in the news. So our goal is to give you the basic foundations so that, hey, where's this coming from? Why are we hearing this about property tax? So stay tuned, join us, and we'll hope to be a good resource for you. Okay, thank you. Jara?
Yes, thank you so much, Jamie and Miss Mabel. So hello, everyone. My name is Jaira Davis, and I am one of the attorneys at the Texas Southern University Earl Carl Institute. The excellent thing about what I do, I am the heirship attorney, so this is kind of exactly in my wheelhouse. And one of my counterparts is Miss Tiffany Bangs, who you will be hearing from at some point later in the month, and she'll be presenting as well. And so you'll kind of see us, you know, back and forth and back and forth. But today I kind of want to present over probate. Probate just in general and clearing title. I'm very happy to be here, and I'm going to go ahead and start sharing my screen with you all. So give me 1 second. Okay, perfect. And I assume that y'all can see that. Can I get a thumbs up? Okay, excellent. Perfect. Perfect. Thank you so much. So please feel free. I enjoy interactive presentations. So, and I know that there's someone handling the chat, so please feel free to ask questions if you have them as I'm presenting. So we again want to talk about how to handle inherited property. So we are clearing title and we are looking at probate concerns today. That's our main goal. So so the agenda, we are going to have an overview of the probate process. It's really important to talk about this because you really can't begin to understand kind of all of the layers of this before knowing kind of what the probate process looks like and kind of how that relates to why you need to clear title. And then we're going to look at the options for clearing title. Again, that's a big part of what I do. And finally, we'll look at property tax concerns. Okay, so let's get into some vocabulary. Let's take it back to first grade and let's just go through the words so you can kind of understand where I'm coming from and what I'm talking about a little bit. So the decedent, it's kind of exactly what it sounds like, and that is the person who died. The decedent is the person who died. Next is the testator, and this is the person who signed the will. So if there is a will, this is the person who signed the will. Next is testate. This is the person who died with a will. And again, we are always encouraging, creating a will, creating an estate plan, but this is a person who died with a will. Next is intestate, intestate, and this is a person who died without leaving a will. And I want to make a quick note here. Oftentimes when we are talking about heirs property, we are talking about someone who passed away without a will. A lot of times we are talking about someone who passed away without a will. And this is kind of exactly what we're getting into. A bequest. Bequest. This is the act of giving an item to someone through a will. Basically, it's inheritance, right? So if your mother has a beautiful diamond ring that you would want, and she can bequest this to you in her will, she can give this to you in her will. We're almost done with the vocabulary. So probate, probate. This is the legal process of administering a person's estate after their death if they had a will, right? So you do also have to go through a probate process if they do not have a will. But if they have a will, that's kind of one of the more common ones we're talking about. Administration. This is the court process when there is no will. Court process when there is no will. So sometimes probate and administration is used interchangeably. They are a little different. Probate is if they had a will. Administration is if there was no will. Executor, executor. This is the person that is responsible for wrapping up the decedent's affairs and distributing assets to the beneficiaries. So let me say this in an easier way. This is the person that is going to pay all the debts and pay out the beneficiaries once the person has passed away. They're going to handle everything in the estate. And then the administrator, this is the person in charge of the estate when someone dies without a will. So administrator and executor, those are very similar, but executor is if they had a will, administrator is if they did not. Okay, so after all that vocabulary, I'm sure your question is, okay, so why do I need a probate? Why do I need to do this? So let's start off. If there is a surviving spouse, you still must probate an estate, right? Or you still must administer an estate. The reason why is because a lot of folks think that, well, this was my husband. I should just be able to get the house, right? Or I should just be able to get into the bank accounts. But what the court system is trying to do is to ensure that things are done correctly, legally, and that someone who is not supposed to get things does not get the things, right? They're just trying to ensure and safeguard all of the heirs of the estate. So if there's a surviving spouse, if you are the only child or children, you still need to probate or administer the estate. So, and if you don't probate the will, so what happens if you don't probate the will? If you say, hey, I'm not interested in this, we don't have enough, we just have a house and a car, and, I'm not interested in doing that. Okay. Well, what happens at that point is that you will not have clear title to the home, and not having clear title to the home creates a lot of problems down the line. You may not feel like there's a problem right now, but I'll give you some examples that we might talk about later too. If there's another hurricane, like what we had a couple months ago, and you need FEMA benefits, those FEMA benefits can only be given to someone who has title to the home. And so that is why clearing title is really, really crucial and important, especially in times of need. Okay. And I want to go on to the next point of, if you don't probate the will, you may also not be able to access the bank accounts. This one is a big one, because if I say, or if someone says, hey, my grandmother, she left me everything. I'm the only person alive. It's all to me. But if you don't probate that estate, that bank is not letting you get that money. Because imagine if if every time someone passed away and someone walked up to the bank and said, hey, this is mine, they gave it away. There would be a lot of problems. So they just want to ensure that everything is done the right way and through the court system. So we talked about probate already, but basically the Texas law does require that you hire an attorney to probate an estate, right? This is not something that you really can just handle on your own. There are some exceptions, but you need to hire an attorney, right, to ensure that it's done correctly. And I will say that, the Earl Carl Institute and some of our other partners and resources, this is what we help with. This is what we assist with, because normally this process does cost a lot of money. And your attorney will assist you with determining what the appropriate probate method is. There are a lot of different methods, there are a lot of different ways to do it, but your attorney will decide, okay, is this, are we probating the will, and asking for letters testamentary? And I'm not going to get into each of these because they're very niche. But the long story short is your attorney will assist you with determining what is appropriate based on the assets in the estate and your goals, right? Attorneys, they're not bad guys. They want to help, and they will assist you with making this determination. So let's talk about some common mistakes, because just like anyone, there can be mistakes made. So one, that power of attorneys, so power of attorneys are only valid during the person's lifetime. Okay. A lot of times we have people come in and say, hey, I have power of attorney over my, deceased mom. I should be able to get into the account. I want to be so clear about this. A power of attorney is void. It is null and void once the person has passed away. So that power of attorney was great while they were alive, but it is useless now that they have passed away. So that's one of the big mistakes that people make, right? The next one is that spouses sometimes will have combined wills. They will have a joint will. This is a huge mistake, right? It's a mistake for one, because sometimes the couple does not pass away together, right? So that's one. But two, they're two separate people. They're two separate people, and they could have separate assets, right? If person A, if the husband maybe has, a bank account and just the house with his wife. But what if the wife, person B, what if she has all of this separate property, meaning she had it before they were married? What if she has all this separate property? What if she has, a house that she bought when she was younger and unmarried, and some cars and some other accounts that she had on her own without her husband? That's going to cause a problem. So spouses need to have separate wills. That's just point blank, period. One of the other common mistakes is kind of referring to the surviving spouse having the surviving spouse and kind of what their interest is in the home after their other spouse passes away. So the surviving spouse is going to have a life estate, a life estate. And what this means is that for the rest of their life, they can live in that home, even if it was separate property. They can remain in the home until they pass away. They do have to maintain the home just like the original property owner would maintain the home. So paying property taxes, whatever else, but they can live in that home. And it's a common mistake to think that once the person has passed away who owned the home, it's a mistake to think that they just have to get kicked out. That's just not the case, right? And finally, another mistake that people make is trying to determine if they are eligible to be an executor or administrator, right? There are eligibility requirements. In Texas, some things did change recently, but overall, that again is something that you'll discuss with your attorney, okay? Now, I know I just gave y'all a lot of information. Does anyone have questions? Should I stop here? Should I pause for a second? How are we doing? We good? Okay, perfect.
Yeah.
Thank you. Okay, so is there a will? So you have to probate a will within 4 years. The probate court understands that one, you are grieving. You do not have to do it immediately. You do not have to do it, within a week or within 2 weeks. It just needs to be done within 4 years. However, you can probate this will as it's called a muniment. Excuse me, I always mess that word up. I'm sorry. A muniment of title if there has been more than 4 years and all the heirs agree. So if it has been more than 4 years and all of the heirs agree, right? And so you're going to probate it as in that way, if again, been more than 4 years and all the heirs agree. So that is the only kind of exception to the 4-year rule. And finally, if the will does not name a beneficiary, and there is no transfer on death deed, which we'll discuss a little bit later, the property will be transferred to all heirs. Okay, so if there's not a named beneficiary and there's not a transfer on death deed, the property will be transferred to all heirs. Is the will valid? Now, I know that most of y'all have probably heard of a handwritten or a holographic will, right? Those are actually valid in Texas as long as they meet their statutory requirements. But those are actually valid in Texas as long as they meet the statutory requirements. But what I'm saying is that it still has to meet certain requirements and certain procedures, right? So one, if the will was not prepared by a lawyer, it has to be in the decedent's handwriting, right? So someone else cannot go and write a will for Joe. That's not how that works. Joe has to write his own will, and then it still has to meet those requirements. Another thing, the will cannot be typed. If it is going to be a typed document, it needs to be completed by an attorney, right? If it's going to be a typed document, it needs to be completed by an attorney. I will also say it is in your best interest to not use a form that you found on the internet. It is in your best interest. I just want to repeat this. It's not in your best interest to use a form from the internet. They are just, you don't know if they're going to meet all the requirements. You don't know if it's going to hold up in court. And frankly, it could cause your family more problems in the long run. It also cannot be a fillable form. It cannot be a fill in the blank form. That's just not, the court is not going to accept those things, okay? So what happens if the will is lost? What this means is that Texas law is going to assume the will has been revoked. Texas law is going to assume that the will has been revoked. They are going to assume that you no longer want to use this will and that you're revoking the will. If all of the heirs agree, however, the court will admit a copy of the will for independent administration. So there is a small way around this. The court will admit a copy if there is an application for independent administration and all the heirs agree, right? It needs to be very clear that this is not deliberate. They're not trying to keep anybody out or there's no fraud being committed. This is to ensure that that does not happen, right? And then finally, another kind of piece about having a will is that if one of the heirs is a minor child and there is no will, you must file an application for dependent administration. Dependent administration. The difference between independent administration and dependent administration. An independent administration is exactly what it sounds like. You are able to administer the estate, meaning you're able to pay off the debts and handle the estate independently on your own, right? You do have to, send the court a couple of things, but overall you get to work independently. A dependent administration it means that the court is going to oversee you working with the estate. They are going to oversee kind of what is being spent, what is being dispersed, how the debts are being handled. They're going to oversee it. And that's not always a bad thing. Sometimes a dependent administration is for the better. It is not always a bad thing. So what if there is no will? So at this point, you're going to look at, so there's application for administration, independent and dependent, and then there's also a small estate affidavit. Small estate affidavit. Hold on one second, actually. Let me see. Okay. So testate versus intestate. We talked about this a little bit earlier when we were going through our vocabulary, but testate means the decedent has a will. The decedent has a will. Now, I will also say if the will has been lost, Texas law again assumes that it's been revoked. If the will does not fully comply with Texas law, the court may not accept it. More times than not, they will not accept it. And finally, the heirs to the estate can still file a will contest. So the person can have a will and there can still be a contest to it, right? And then intestate means that the deceased does not have a will. And I want to repeat that this is most of the time what you're dealing with when you have heirs property. An intestate estate meaning that the person did not have a will. So probate assets. When you are looking at probate assets, you are trying to decide what can pass under a will, what can be put in a will, right? And these are things like real property. So, 444 laptop drive, right? That is real, that would be, an example of real property that can be put into a will. Personal property, household items, furniture, clothes, car, jewelry, art. An example, again, grandma's engagement ring, right? Your favorite teddy bear, right? Your music collection. Those are personal property items, examples of personal property items that can be put in a will. Non-probate assets. Non-probate assets. Non-probate assets are items that do not pass under a will. And what's excellent about non-probate assets is that these can be taken care of, again, without going through the probate process. And I want to harp on this. Please, 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 you will save your family so much strife if you just put a beneficiary on your life insurance, accounts, and on your regular bank accounts. Okay, I want to really harp on those two things. You can call your bank. So if you have Chase, Bank of America, USAA, whoever you have, if you call them and say, hey, I want to put a payable on death beneficiary on my account. Because unfortunately, when you open your account, they do not all the time ask you if you want to put a beneficiary on your account. You say, hey, I want to put a payable on death beneficiary on my account, right? What they are going to do, they are going to either take the information over the phone or they're going to send you something. It is that simple. And what that means, a payable on death beneficiary is someone who they don't have access to your account immediately. They can't take money in or put money out or whatever. What they will do is after you pass away, they will give the bank whatever information they're asking for. Most of the time it's like a death certificate, an affidavit, whatever, and they will be able to have access to those funds. And that is really important for families who maybe want to have, some sort of celebration of life, or who need to pay the mortgage, or who need to do certain things. So that is such a critical way to get things handled. And I will also say that if people would just put a payable on death beneficiary on their accounts, I cannot tell you how many issues would be handled if this could just get taken care of. And the same with life insurance, with your life insurance policy. Please add a beneficiary. Ensure that you have a beneficiary. And the last thing I'm going to say about this, because I'm sure y'all are tired of hearing me yell at you. The last thing I'm going to say about this portion is you also have to check this often. Please check this often. You may put beneficiaries on your account one time and then forget and then go on about your life. This person who you put as your beneficiary, they could have passed away. They could no longer be in your life. Anything could have happened. So please go back and look at this at least every year, just to ensure that everything is how you would want it to be, okay? So some other examples: retirement plans, 401ks, and joint tenants with rights of survivorship. Okay, so now we're getting into some probate procedures, okay? So what is a small estate affidavit? A small estate affidavit, they are truly only appropriate in a number of circumstances. These are not always appropriate, but a couple of the kind of elements of a small estate affidavit: the value of the estate can be no more than $75,000, excluding the homestead. So we understand that most homes cost more than $75,000. So this is, your estate cannot be valued at more than $75,000, excluding the house, right? But this does include the car, the car, the bank accounts, other things. Also, the debts cannot exceed the value of the estate. Okay, so you cannot have, you cannot have a higher amount of debt than what the value of the estate is. Okay, also that's another thing. This is the only, and I mean the one and only, probate proceeding that does not require an attorney in Harris and Fort Bend counties. That's why I said earlier there's an exception. This is the exception. Let me be clear though. It would still be helpful, it would still benefit you to talk to an attorney before you do this, because it is still a court document. So you do have to be correct in your calculations, what you're giving to the court and what you list on the application. All the heirs have to sign it. So this still has to be correct. They're not going to accept, a half done or an incorrectly done small estate affidavit. And that's why it still might be helpful to go to an attorney for this type of document. Okay. And you can find a sample of this form at texaslawhelp.org. And texaslawhelp.org is a fantastic website. So some more things I said earlier, all heirs must sign the affidavit. You cannot file a small estate affidavit if the person had a will. So this is not for if a person has a will. This is for if a person dies without a will, meaning they died intestate. Okay. And it does have to be signed by 2 disinterested witnesses. And a disinterested witness is a person who basically is very aware of his history. So they understand the family's history, they understand the decedent's history, and they do not have a financial interest in the estate, right? So a child of the decedent would not be a disinterested witness because they are an heir and they do stand to gain financially from the estate, okay? And finally, a small estate affidavit only transfers the homestead to a surviving spouse or a minor child. A surviving spouse or a minor child. That's why a small estate affidavit does not work for all cases. And that's why you really should consult an attorney before trying to complete one to see if your, if your late loved one's, estate even qualifies for a small estate affidavit. Okay, so now what we came here to talk about, which is how to clear title to heirship property. Why do we need to clear title? So we talked about this earlier, right? There are just certain things that you need to take care of. There are certain reasons that you would need to clear title. But basically, if your family has this one house that has been passed down from grandma to mom to you need to clear title, most likely. Right? Or if auntie, bought the house a long time ago when they first came over, and then it's been passed down through generations, you most likely need to clear title. So has that house, has that piece of property been in your family for more than one generation? And is the property deeded to the current resident? So if you're the person that is living in that property right now, today, currently, is that property deeded to you? Is that property in your name? If not, you will likely need to clear title, okay? And clearing title is important because, again, earlier we discussed if you ever need FEMA benefits, right? And I think that's here. You cannot qualify for assistance through programs with the city, state, or national government, right? And many people don't learn about needing to clear title until they need the help, right? Until they need the help. And that's when you need it the most. And you're like, dang, I didn't even know this. You also can qualify for property exemptions, right? You yourself may qualify for property exemptions if you're over 65, if you are persons with disabilities, or if you're, a disabled vet and you're at 100% disabled. So there are different reasons why you would qualify. But again, your name has to be on the deed of the property for you to get those exemptions. It was explained really well last night. The exemptions stay with the person, not the property. So I will also say a new person can't, the next family member can't move on the property and get those same exemptions if they don't qualify. The exemptions are for the person, not the property. So some judicial proceedings for clearing title. So this is what we talked about a little bit earlier, that word that was really tripping me up. So this is where there is no need for estate administration. You can file this instead. And kind of what I mean is the only thing you need to do is transfer title. So this is what you would use if the only thing you need to do is transfer title. Now, an attorney does still have to complete this process for you. And again, a number of our offices will handle this for you. But this is if pretty much all you need to do is transfer title. Now, there is another way to handle this. And well, let me not jump ahead of myself, pardon me. So as far as, this kind of probate process as well, some of the requirements are that it has been more than 4 years since the date of death. And you also have to prove that like the delay was not intentional, right? The court wants to know that you didn't hide you weren't hiding anything, none of that. Like you just did not know that you had to probate this will. Again, all of the heirs must agree to the probate. All of the heirs must agree to the probate. And also, you're filing a certified copy of the signed order in the real property records. And so what's going to happen, the county clerk is going to transfer the property to the person named in the will. Okay, so that's how you're going to handle it. You're going to file it with the real property county clerk and the real property clerk, and they are going to transfer the property to the person named in the will. Quick thing we're going to discuss is adverse possession. So adverse possession is when someone essentially is going to obtain legal title to a property through a lawsuit. Okay, so a lot of people have heard of adverse possession. This is kind of something you may see on TV or may have heard of in another way. But this is going to be, again, when a person is going to, I guess, get legal title to property that they did not have legal title to before. Okay, so they didn't have it before. They but there are really specific requirements and time periods in order to obtain this, in order to obtain this, right? It is not easy to get it. There are a lot of requirements because in the state of Texas, no one wants to just lose their property when they had it legally, right? And you have to do this the right way. And the other thing is that the court is very strict about this. So if there's any of those requirements missing, you cannot claim property by adverse possession. Okay, I just want to be very clear. It's not an easy thing to claim. So non-judicial methods. So this is without the court. How do you clear title? So this is what I do a lot of, and it's something called an affidavit of heirship. This is something I do a lot of. I just want to repeat that. So one, you are going to have 2 disinterested witnesses who knew the deceased person, right? They are going to give facts about the deceased person and their family history. Okay, they're going to give facts about the deceased person and their family history. I will give you some examples. They will list down who they were married to, who their children were, who their grandchildren were, who their parents were. So that's the type of thing that they need to know. And they also need to know those folks' first and last name and their date of birth and their date of death. So when you are considering who can be a disinterested witness, you're not looking at someone who knew the family for a year or two. No, no, no. Most of the time, this is going to be someone who knew the family for 20 years, 30 years, right? They watched all the kids grow up, something like that, okay? The affidavit of heirship must be notarized. And with this, title is transferred to all heirs, okay? I want to be very clear about that. When the affidavit of heirship is created, title is transferred to all heirs. So there's not one heir that gets it over the other. It's transferred to all. And when your affidavit is complete, it is filed with the county clerk in the county where the property is located. So if your property is in Houston, Harris County, you are going to file it with the county clerk, the Harris County clerk. Okay, that is where you're going to file it. There is a minimal filing fee. It's $18 for the first page and $4 for each additional page in Harris County, right? And a lot of times these things are a lot cheaper than the alternative. So it's a couple, $20-$30 is much cheaper than what some of these other procedures would cost. So an affidavit of heirship, again, a sample can be found on texaslawhelp.org. Again, excellent site, but it is critical that you use the full legal description. The full legal description. And this is the description that is going to be found on the deed of the house. So this is not, the description on your property tax bill or what you find on, any of these websites. Most of the time, that's not going to be the full legal description. It is going to be what is found on the deed of the house. Okay. It's going to be long. It's going to be a couple lines long, and it looks official, in my opinion. So it's going to be quite a few lines long. It's not short, and that is going to be found on your deed. Okay. So this is an example. Legal description, lot 11 in block 72 of Noble Edition, a subdivision, So this is a great example. And then you're also going to say commonly known as 1505 Terry, Houston, Harris County, Texas 77009. Okay. This is what a legal description looks like. And versus a tax description, which is not sufficient, right? So this is what's going to be sufficient, and this is what is not going to be sufficient. This is too short. It is not sufficient, okay? This is not sufficient. I want to be clear about that because people do get confused. So how can I prevent having to take care of how can I prevent having heirs property that isn't passed down, where the title isn't clear? How can I ensure that I don't do this? I don't give this issue to my family. Well, one, you can execute a will and you can name the person who you wish to have the home. That is a good option. Another option is something called a transfer on death deed. And I want to be so clear, a transfer on death deed. I want to be so clear. I believe in this so much that I ensured my parents had one. Okay. So I'm not just someone telling you like, oh, I think this is a good idea. No, I think this is a great idea. This is one of the best things we have. This is not available in every state, but it is available in a number of states. A transfer on death deed allows you to transfer real property after you pass away without the need to probate the estate. Okay. You do not uh lose title to the property. You don't have to get off the property, none of that type of stuff. You keep, your title, you keep everything until you pass away, and the beneficiary that you name gets it almost immediately. All they have to do is go down to the property clerk. I'm sure they'll ask for a certificate, a death certificate, some sort of affidavit, driver's license, different things like that. It costs less than $50. Okay. And they are able to they're able to get the home in their name, the title in their name. This is the difference between $32 and $3,200. Okay. This transfer on death deed, I mean, there's examples on Texas Law Help, I believe. I think a number of our offices do it. This is the thing to do. And again, it is the difference between $32 and $3,200. This really will save your family so much in the long run. And I know that for a lot of us, our goal is to keep our homes in the family. We didn't work this hard to buy a home or to buy our first home for it to just get taken or given away quickly. No, we want it to stay with our children, our grandchildren, and so on and so forth. And this is a way to do this. So I kind of just talked about it all, but basically, a transfer on death deed, it is going to allow the property owners to record a deed, naming a beneficiary to own the real property after they pass, right? You retain full ownership during your life. This is all the things I just said. Again, you must include the full legal description. So that thicker block, not the thinner one, but the thicker one. And you must record it with the real property records of your county clerk prior to your death. That's a really important part. It has to be done prior to your death. What's excellent about the transfer on death deed, it is revocable and it is amendable. You can change it. So you can change it and you can revoke it. If at some point something happens or, something changes, you can always make those changes. This avoids probate and it saves your beneficiaries time and money. And the final thing I can say, without probate, the Medicaid estate recovery program, they cannot seek reimbursement here. So you can find a sample form on texaslawhelp.org. Again, excellent website. Excellent website. One of the final things, an enhanced life estate deed. So many people call this a ladybird deed, this is commonly used in Medicaid planning. Okay, so it's a little bit different than a transfer on death deed, but it is commonly used in Medicaid planning. You retain full ownership rights during your lifetime. You again must include the full legal description, and these are also revocable. Okay, these are also revocable. Now, how do you get this legal assistance? Now, I don't think that this is every partner. I also don't, this presentation was created a little while ago, so I do believe we're missing some folks, so I apologize for that. Truly, I do. But these are just some of the options on, where you can get legal assistance, who can help you. These are just some of the options, right? A lot of our partners, we do this work. And I do want to ask, does anyone have any questions? Was this helpful? Did you understand what I was saying? What do you think? I really want to hear y'all's thoughts. And I can't see the chat. I apologize.
I have a question.
Yes, ma'am.
I apologize. So when you came out to do your presentation at Synchronous Thompson's event last week, it was very good. And you gave us some brochures to contact you. I called that number and I kept getting a recording, and it told me to go online to that link. I think Earl called /apply for help. When I first tried to do it through my phone has Google Chrome, right? And I was able to go through that link. And then when I noticed it was asking me for financial information, I said, oh, let me go ahead and try the desktop version for safety purposes. So when I tried to access that link through my desktop, on my desktop, I have, I think, Microsoft something. I forgot what it is. It's not Google Chrome. And when I typed in that link, it went to something else. It wasn't your link. So I was just letting you know that the only way I could access that information to your institute was through Google Chrome. I didn't know if you knew that.
Okay, I will, thank you for letting us know. I will take a note of that. I sincerely apologize. And I do hope that you were able to fill that out. I will check on that and let you know, and let them know.
I had to upload access Google Chrome. I was able to put it in the application. So my question is, from the time that I put my application request in for assistance, what is the approximate turnaround time for me to find out, okay, you're going to accept my case and assist me, or you're going to deny me, or what? I'm asking it because I do need your assistance. One of them is because of for FEMA assistance.
Okay. So from what I understand, and I'm not a part of like the front end of things, but from what I understand, as soon as an application is sent in, we have like an intake process, and then I think I'm supposed to like receive an assignment, or at least look at it within a couple of days. So we should be able to look at your case in a couple of days. Again, I'm not sure, I'm not a part of that part of the process, but we should be able to get to it pretty quickly. And then from there, we'll be able to tell you if we, after we investigate, we'll be able to tell you if we can move forward.
Okay, because I put the application for assistance in. If it wasn't this past Sunday, it was definitely Monday this week. So I don't know if your process, a 2-week turnaround time, 5 business days, I don't know.
Okay. Okay, well, I will, and we'll look out for it, and we'll try to get to you as quickly as possible. And I'll see where we're at in the process with your application.
Okay, because sometimes some people say, oh, if you haven't heard from us within a week or two, please contact us for follow-up. I haven't seen anything like that on your website for follow-up instructions.
Okay, no problem. Well, thank you for letting me know, and I will, and I'll check on that for you. And thank you for your question. I really appreciate it.
Thank you very much. Your presentation was excellent.
Thank you. Thank you. Okay, I see a question in the chat. And I will go ahead and read it out. The question was, how do you check your beneficiary? Annually, is it sent to you? So as far as like life insurance, for instance, or your bank accounts or anything, right? I would always call my institution. they should be able, it is their job to give you that information, and it is their job to help you, list a beneficiary if you do not have one. So what I would do, I would call your institution, your life insurance or banking institution, to see if you have a beneficiary listed. And, I would ask who that person is, or I would list someone if you do not have someone listed.
All righty. Oh, all righty. Are you about ready for me to go? If you want me to go ahead, I'll go ahead and share my presentation and get started. Hey, thank you, Jara.
Thank you.
Okay, well. All right. Good after. All right, is it showing on the screen now?
No,
Can you
ma'am.
guys see my presentation?
I don't see anything yet.
Nope. Okay. All
Yeah.
right. What about? Nope.
Not yet.
It was doing fine. Okay. All right, let me try this again. Okay, now, okay, I'm on there and share. And okay, what about now?
Yes, I see it.
Okay, and let me just. All right. So good afternoon, everyone. Now, mine, okay, you can all see it. Okay, good afternoon, everyone. You can see it, correct? So I just hit another button. Everybody can see it?
You can see it.
Perfect. Good afternoon, everyone. Once again, my name is Mabel Menifee, and after all of the information that you have heard from Jariah, I am going to just basically kind of go over some of the finer points of the exemptions process, because that always plays an important part often in clearing title and property. And a lot of times people don't, it's important to get how they all fit together in terms of property taxes and any past due property taxes, any exemptions that perhaps should or should not be on the property. So we're going to talk a little bit about that to maybe help tie all of this in for you. So I also with me today, excuse me, if you have any questions, my colleague Frida Claiborne is in the chat room and she'll be happy to answer those or make sure we get you an answer if we don't have one for you today. And also, I'm going to talk about the appraisal process, and then I'm going to be followed. I'm going to briefly talk about that, and then I'm going to be followed by the tax office, which represents kind of the opposite side of the property tax coin. And that way, it gives you a more complete understanding of how important and just what the role is as far as property taxes in Harris County is concerned. So let's go ahead and get started. I don't think I really have to tell anyone what property taxes are in Texas. They help support your police, fire departments, school districts, etc. Some people say, oh, property taxes are fairly expensive in Texas, and that's primarily because the state has no income tax. So property taxes do tend to play an outsized role here in the state of Texas. All property tax laws, including those that HCAD must abide by and administer, originate with the state legislature and are embedded in our state laws and constitution. Local taxing units, as I mentioned before, is what they support in the local services they provide. Central appraisal districts like HCAD, there's one in every county. We are responsible for appraising all the property in that county, and that includes residential property, which we're going to largely talk about today, as well as agricultural, industrial, and business personal. We're required to appraise that property at 100% of market value. We also administer the exemptions, which is probably why I'm here today. And we also certify the appraisal rolls each year something that must be done in order for each of the taxing jurisdictions to understand what their funding might be for the year, and then that allows them to determine what their budgets are going to be, whether or not they may need to raise or lower their rates. So a lot of that's going on. It's that time of year for that. So a lot of that's going on right now. Some of you have probably seen articles about some of those jurisdictions who are looking at raising their tax rates. So just quickly, very quickly, one of the reasons when you get things from the appraisal district in the mail, we, as you can see, you saw earlier, we operate on an annual calendar because those jurisdictions need that information annually. So January 1st, that's the date when we appraise all property. That means that whatever the condition or the ownership or whatever the property was on January the 1st, that's the date of appraisal. Something can change on January the 3rd, but in most cases, when it comes to condition of the property, it's going to be based on that January the 1st date. If something still remains the same when that following January rolls around, that's when you might see a change based on whatever happened that previous January 3rd. May 15th, that's the protest deadline. When you get your evaluations, that's when you have usually 30 days or until May 15th to file a protest. If in fact you disagree with the appraisal district in terms of what the value that was placed on the property is for that year. October, November, where we are now, that's generally when tax bills are being calculated, soon to be mailed out. Jamie's going to talk a little bit more about that. And then, of course, if they aren't paid by February the 1st, they become delinquent. We are at HCAD, the Harris Central Appraisal District, are required by tax code to be at 100% of market value. So we're under that pressure from the state to make sure that we are as accurate as possible when it comes to market values of properties. The state actually conducts a biennial study to make sure that we remain on task and are doing that properly. We do so by something called a process of mass appraisal. That is a process that's a little bit different from what you might have experienced in the past if you had a fee appraiser, because the values are derived on the sales within that area. And here at HCAD, we are the largest appraisal district in the country. Even though we're the 4th largest city, we're the largest one in the country that appraises property annually. That's approximately 1.9 million parcels. And believe it or not, there are over 500 taxing jurisdictions in Harris County. You may only pay to 4 or 5 of those, 5 or 6, but depending on where you live, you pay to different ones. And so those all total up to 500 or more. This is what you might receive with the appraisal district. That's the annual value notice that you get in the mail. If you've not seen one before, you may be receiving one for property that you've just taken over. This is what it's going to look like. It usually comes out in late March or early April. However, if it's later, you always, and if you're interested in filing a protest, you have until May 15th to do so, as I mentioned, or at least 30 days from the date that is on the letter that you can see up here. Okay, and just a quick, when you get that letter, just kind of to help people understand what the appraised value versus the market value. The market value is what HCAD determines each year. And that's the value at which we, based on the sales in the area, determined that the property would sell for to a willing buyer on the open market in a fair market transaction. That's our primary role, to establish that market value. It's also important to remember that that is the value that you would be protesting, or to file an appeal or protest with HCAD. The method, quickly to go over those methods, and I will mention that I'm going over these fairly quickly simply because usually in the spring when those value notices come out, we conduct extended protest workshops which help to understand the valuation process a little bit more, as well as how you might go about protesting and the many different methods that you can use to protest. So we're not going to get into that today, but if you're interested next year, then please feel free to check the schedule. We do some here virtually on the AMOS platform, as well as some in person for individuals to help them understand and participate in that protest process. But as you can see here, there are different kinds of protests that you can do. I also want to kind of go over just a little bit. Now let's get to the meat of why I'm here today to talk about exemptions and what they are. They typically save the homeowner money, and you might want to know how they get them. Now, Jerai mentioned earlier, as we say time and time again to folks, that when we talk about exemptions, it's going to be your qualifications. The exemptions are going to be based on how you qualify, your age, whether you're it's your primary residence, a number of other things. But it's important to remember that when you move into a new home, those exemptions that may have already been on that home are not yours. They belong to the previous owner because the previous owner did qualify for them based on their personal uh, uh, exceptions. So what are they? They basically, HCAT administers them, and they exempt a portion of your property's value from taxation. It's usually on if you're a homeowner, it's going to be on your primary residence. That means the home that you occupy, that you live in. Now, the exemptions are basically considered something like a discount. They're used by the taxing authorities in calculating your property value, your property tax bill, excuse me. And basically, if you're, just to give you an example, if you have a $300,000 home and you have an exemption, a school tax exemption of say $100,000, then your tax bill is going to be calculated on 200,000 rather than the actual value of 300,000. So that's how an exemption gives you a discount. Some of the most common and the ones that you'll find on almost any home is a general resident homestead exemption. That's available to anyone with a that has a primary residence. If there's an over 65, we'll talk a little bit about describing the over 55. There's a disability. There's some exemptions as well for disabled veterans, and then there's some other service-related exemptions for first responders and the like. General resident homestead exemption is the most common. It requires the own and occupy the home. When you would file that with HCAT, and you do need documentation. We do require some documentation, basically the proof of ownership, along with a copy of your driver's license when you file it. And that driver's license does need to, the address on the driver's license does need to match the address on the property to provide additional proof that that is your primary residence. So this general resident homestead exemption, one of the first things you get is something called a 10% appraisal increase cap. That's something that caps the amount that your taxes, that your value on the property and your taxes can be calculated on that. The value can never go above 10% of what it was the year before. Now, why is that important? In Harris County, I'm not sure if I need to tell anyone that we have areas where property values in past years, they slow down a little bit now, but in the last several years, we've seen them go up as much as 20, 25, 30% in some areas, maybe even more if you're looking at it long term. And so each year, annually, that 10% keeps people from having to experience such a huge increase in their value, therefore in their taxes. Their value may go up, but they're going to be capped in terms of what the appraised value increase is going to be for that year by at least by 10% or less. The 100% school tax exemption. Now that's something that you guys voted on and approved in last November's election. I've raised the school tax exemption from 40,000 to 100,000 for people with the general resident homestead exemption. Basically, as I said earlier, it takes $100,000 off the value of your property as part of when your taxes are calculated. There may be other exemptions that are also offered by different jurisdictions, and that kind of depends on where you live in the county and which jurisdictions you're under that you would receive. The over 65 exemption. Now, this is an exemption. You can't have this exemption without the general resident homestead exemption. So it's a part of that. And what basically it does is that once you turn 65, you get some additional benefits, some additional discounts. You qualify for it the entire year that they were 65. So, and the over 65 exemption and the disability exemption are generally one and the same. They offer pretty much the same benefits. The disability exemption, you don't have to be 65 for, but you can qualify for it when you become eligible to receive disability exemptions, disability benefits, I should say, under Social Security, or some people who may not be receiving Social Security can also provide a physician statement to HCAD, or the physician can provide a statement to HCAD saying that you are disabled and unable to work in order to qualify for that disability exemption. Now, what are the additional benefits that you get from this over 65? You get a school tax. The person gets the school tax ceiling or freeze, as it's called. Basically, that means that the school taxes for that year that year that you turn 65, they freeze at that amount. They won't go up. It's a ceiling. They won't go up any higher than that, unless the only reason they would be because you did something like you added some significant value to the property, like additional square footage. You built an extra room, you put a swimming pool, you dug a swimming pool in the backyard, that kind of thing, in which case you've actually increased the value. So your tax ceiling might need to be reset just a little bit before it sets in again. Again, you get all the benefits of the resident homestead exemption. And you're also eligible for something called a tax deferral, and you can pay taxes. You can actually pay your taxes in installments without penalties with that benefit. Again, there may be some other additional exemptions that would be granted by individual jurisdictions. It just kind of depends on where you live in the county. The over 55 is one that just serves as a reminder that if a spouse passes away and they had reached 65, and so the household was receiving all of the over 65 benefits because one of the owners had turned 65, and say that owner passes away. If that happens, if the surviving spouse is at least 55 years of age or older on the date of that of their spouse's death, they will be able to maintain all of those exemptions that were previously in place, those over 65 exemptions. The school tax ceiling is something that also continues. And again, they continue to be eligible for tax deferrals, and they can pay taxes in installments with no penalties. Now, I want to be clear when I say this, because we're going to go into a little bit. I mentioned exemptions and I mentioned deferrals. And I want to mention this because there is a lot of confusion that we found in the community when it comes to exemptions versus deferrals. And it's important to understand, and you may even hear this in a conversation and you can help clear that up, that exemptions are merely a discount on your property taxes. You get that. You get a discount just as you would go to a store and purchase something on sale and you get a discount. You don't pay it back. You're getting that additional savings. A deferral, on the other hand, is something that a little bit different in that you're merely postponing the taxes until a later date, and you can do that. It's part of the options that someone with an over 65 exemption has. And I wanted to mention that too, because there's a lot of misunderstanding. There are people who may not apply for the over 65 exemption because they think it means that they would have to pay that back, or that their descendants, their heirs would have to pay that back. That is not the case with the over 65. As long as that person was eligible for it, they will receive that over 65 as just a discount. The deferral, on the other hand, is something that you would need to pay back later, or that the heirs would pay back later. And they're going to talk a little bit more about that in the next in the tax office's presentation. But I wanted to bring it up first, so it'll be something that you continue to listen for, because it's a very important piece to get out there in our community, because there are folks who are not taking advantage of that over 65 exemption who really should be. So this is another one that's important to some folks out there, particularly folks living in mature neighborhoods and communities, called the heirship exemption. And it's part of the application that you would see if you were applying for exemption from HCAD. But there's a section there that's going to ask the question, is the property submitted as an heir property? Now, you may live in an heir property where there are several siblings that still own the property, but you may be the person that's living in the property. while your heirs may actually live in another state, they may have their home across town, that they're receiving their general resident homestead exemption. Previously, because you were not you did not have 100% ownership, you may not have been eligible to receive an exemption, a general resident homestead exemption at 100%. You might have gotten it if there were 4 of you, 4 heirs. You may have been able to get it at 20%. When you get that's this section on the application, if you are an heir living in the property, the law does now allow you to receive 100% of the exemption without affecting the ownership rights of any of the other siblings. It just gives you're there in the property, you're taking care of it, so you should be able to get that exemption. So there's some questions that it would ask. If you check yes, is it an heir property? You can see here in the red, and do other heirs occupy the property? Then that sort of triggers some additional information that we're going to need in order to make sure that that heir property, that you can get that exemption. So when you do that, just make sure if you have any questions, it does state, it's going to state on there everything that they need with it. But if you have any questions, please feel free to call HCAD, talk to our exemptions department or our front counter, and I'll give you that number later. And they will be more than happy to help you and to walk you through that process if that is if you are seeking that heirship exemption. Another one that was just recently passed, the immediate resident homestead exemption, and this is going to be for folks primarily moving into property that was previously rental or brand new construction, property that did not already have an exemption attached to it. And this is for the owner himself. The previous owner, that's what allows you to, previously you had to wait until January the 1st of the following year in order to qualify for exemptions. Now you can qualify for them that the month that you move in. It's going to be prorated depending on how many months that you've lived in the property, but you can start receiving them that first year. And then the second full year is when you would get that full exemption. It's also going to be the year that your cap eligibility will be set so that you can begin receiving that 10% appraisal increase cap. The exemption forms, how do you get those? How do you check on exemptions that you're not sure you have, or you're not sure whether someone else in the family that you may be checking on have them? You can go to our website, and I'll give you that information. And if you will also need to apply for an exemption, there's a paper form you can fill out. There are online fillable forms at the HCAD website. There is a mobile app that you can also use, or you can simply fill it out, copy it, and email it to us. And depending on when that's submitted, you want to make sure you submit everything at once. And as I mentioned before, be careful, look at the paper carefully. You make sure that you send in that driver's license, or the driver's license of whoever, say there are 2 co-owners. You want to send in the driver's license of both of those, and you want to make sure that they show the address on the property as the same on the driver's license. Please try to submit everything at once, because if you don't send in all of the information, then you kind of get, we're gonna send out information or letter to you requesting the additional information, and it kind of kicks you to the back of the line again. So you don't want that delay if you can send it all in at once. And once you've applied to your account, you will be notified. I also want to mention that a how-to video for anyone who feels a little bit insecure about going out and filling out that form online, we now have a video that you can actually goes along with you, can be played along as you go filling out the form. So keep that in mind. You can follow it along as you fill out the form. So it makes it a lot easier for people now to fill it out. One thing I did want to mention, and I know a lot of people get this, sometimes you'll get cards in the mail or people saying they can offer you, they can make sure that your property taxes are cut because they can get you exemptions. They may call it something like designation of a homestead, and they'll say for a small fee, They will do this for you. I want people to keep in mind that acquiring your exemptions it's free. It does not cost you anything. You simply need to fill out the paperwork with HCAD. But there are vendors out there that will try to sell you that service. So just remember, you don't need to purchase that. All you need to do when you're applying for an exemption, or if you have questions about an exemption, contact us, contact HCAD. Now, one last thing before I close out is I did want to mention this for any of the folks out there listening. If your property was damaged by Hurricane Beryl, and this is a relatively new exemption that came on board maybe 3 or 4 years ago. It's something called a temporary exemption for property that was damaged by a disaster. The governor has to declare it a disaster, which he did. You have 105 days to file for that after the disaster declaration. The deadline to apply if you had damage from Hurricane Beryl is October 21st. So that is coming up. Please keep in mind too that it must meet a damage threshold. You have to have had at least 15% of damage to your physical property in order to qualify. And HCAD's appraisers will work with you on that once you file the application. But if you're in doubt, still go ahead and file the application, and they'll either tell you yes, you qualify, or you do not. So wanted to make sure October 21st is the deadline for getting that. You can find that application on our website at hcad.org. And then finally, for those of you who have been listening to the clearing title presentation, as well as the exemptions, and as mentioned before, you may be moving into a home that was previously occupied by a relative, and they may have had some exemptions on the property that you may not be eligible for. Sometimes people forget. Sometimes you got a lot more to do. You do want to make sure that you take care of those as soon as possible. And one of the things we do to help, I think, is we send out something called an annual exemption card. It usually goes out in late December or early January. And on that card, it's a little postcard, and it basically just says, these are the exemptions that you receive, that you'll be receiving. And it basically says if you still own the home and they haven't changed, they're going to automatically be applied to the next year's property tax bill. If they have changed, then you need to contact HCAD and let us know what the changes are so that we can recalculate whether or not the current homeowner, the current person owner is qualified for those exemptions or another. You know, it's important to do this because it's required by state law, as well as in the event that you move into a home and you are not eligible for the exemptions that are already on the property, and you did not, which was for the previous owner. State law allows us to go back. You can be assessed for up to 5 years of any property, any taxes that you owe because you were not eligible for those exemptions. So please go ahead and double check that. And if anyone out there now is looking and scratching their head based on what I've just said, so do I have my exemption to do my over 65? You can always go out to our website and check on that. You'll see where it says, when you type in your address under the property search tab, it's going to say under the exemptions column, it will say residential homestead exemption. And so you know you have it. If you're looking for your disability or some over 65 or some additional one, it's going to say residential homestead, but it will also say multiple in there. And you know which one you're looking for. State law doesn't allow us to state whether a homeowner is over 65 or disabled, because that's confidential information. So you would know based on the term multiple which one you had. So that is about all of my presentation today. I quickly want to just show you the landing page on our website, where I mentioned property search here up in that second blue line to the left. And then you'll see, if you continue across, you'll see forms. That's where you can click and get any of the forms that you might need to fill out including the exemption or the over 65 or change of address, whatever. They're all up there. And we also have some other helpful videos as well. And this is our contact information. You can reach us. We're out on the Northwest Freeway, or you can call our general phone number, or you can reach us again, that's our website address. You can also send in information online to our eBank help desk as well. So that's basically the information that I wanted to share with you today, and I hope it's been helpful in clearing up any questions you might have about exemptions on inherited property or any other questions about exemptions. So thank you very much. And I am now going to hand you over to my colleague down at the tax office, Jamie Duong, and we'll be around to answer any questions. Thank you so much. Oh, Shay. Well, then I'll hand you over to Shay Pentowski. All yours, Shay.
We cannot hear you.
Ding 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 ding. Hello.
I send you the phone number in case you want to call by phone.
Okay, can everyone hear me okay?
Yeah.
All right, hello everyone. Can everyone hear me okay now? Sure, hope so. Fabulous. I'm seeing nods, I'm seeing thumbs up. Awesome. Thank you so much for your patience. I am so sorry about that. Not real sure what happened with my mic. But good afternoon. My name is Shay Pinkowski. I am with the Harris County Tax Assessor Collector's Office with Ann Harris Bennett, and I'm here to talk about probably the least fun topic that we're touching on today, which is property taxes. And while it's very necessary, it's not going to be everyone's favorite conversation, but it is full of very important information. So if you have any questions, any doubts, please feel free to, ask in the chat, or if you'd rather wait until the end to ask questions, I'm very happy to answer any questions y'all might have. So let me go ahead and get my, my screen shared here. So hopefully everyone can see this, but this is, again, the Office of Ann Harris Bennett. And just to start us off with some brief information about what all we do as the Tax Assessor Collector's Office is we do maintain accounts for 1.7 million property tax accounts, meaning this is all kinds of property such as businesses, individual homes, even just plain land, mineral deposits, anything of the like that collects taxes for is included in what we collect for. So we collect over $8 billion in property taxes usually this past year, and we collect for, I think it's more than 79 now, but previously was 79 taxing jurisdictions. Our most common ones that we collect for everyone is going to be, our Harris County taxes, our City of Houston, Houston ISD, along with the flood control. And we do collect for other jurisdictions as well, so we'll collect for other water, emergency services districts, and some schools. So depending on where you're located in Harris County will depend on what all you're seeing on your bill. So let's move on. Just a brief visual representation of how your taxes are calculated and then dispersed onto you so that you're able to see what your tax bills are for the year. We receive our taxable value information from the Harris Central Appraisal District, which was Ms. Manafee's office, who we just heard speaking a few minutes ago. They determine the appraisal value of your property and the taxable value based off of the history of the property itself, which is then multiplied by the tax rate. The tax rates are the percentages on which we collect property taxes, and these are determined individually by the jurisdictions themselves. So each emergency service district, each school, each MUD or utilities district, and even the Harris County districts all determine their rates individually. So that all gets taken into account whenever you're having your information process for the year, and right now they're kind of in the middle of determining those values and putting everything to votes. Anything that needs to be pushed to an election will be, and this is kind of the part of the process where everyone is determining what those rates are going to be for this upcoming year, which will then determine how they're able to use that that budget to their best ability for the next upcoming year. And once we have that information, that is how we calculate your tax bills. So the reason that you are owing whatever amount it is that it says you're owing on your tax bill this upcoming November is going to be determined based off of your taxable value, if you have any exemptions, and then the tax rates. So this part is important for everyone to be involved and knowledgeable about what is going on currently. So keep your eye out on the Houston Chronicle, keep your eye out for general pages in newspapers, magazines. They'll have that information out there. So, stay informed and stay aware of what all is going on around you. We recently had some property tax law changes this past year. The increase for Harris County taxes for over 65 and disabled exemptions went up from $229,000 to $250,000. Same with the City of Houston. They also had an increase from $160,000 to $260,000. And of course, a lot of you are familiar with the school exemption, which was a statewide change, which instead of having an exemption for homesteads of $40,000, it is now $100,000. So that's just more of those discounts being applied for your property taxes. And that's only for the school or for the Harris County and City of Houston distinctly, but that information is carried on through the state. And in the Harris County and City of Houston, those are individuals, so they determine what their exemptions are. The homestead exemption is now eligible for proration, meaning that previously you would have to wait for the first full year in which you occupy and own your home in order to have your homestead exemptions applied to it, whereas now, from the day that you move in, you would be able to apply for your homestead exemption to apply from that date forward, meaning you wouldn't have to wait for the first full year. So if you buy your property early in the year, you can have it for most of that year as opposed to having to wait for the following year for those exemptions to be applied, which is really good for those new homeowners. We had, again, the increase for the school homestead exemption from $40,000 to $100,000, which did result in some pretty drastic differences for, totals on your taxable values this past year, including my own. We were able to through the 88th legislature, reduce, or rather increase the limit for certain property taxes, meaning that certain property taxes amounts were limited. And through some reconstructing to the school financing systems, they were able to do a rate compression, meaning that a lot of you saw a really big drastic difference in your property taxes for your schools specifically, which in turn, meant that you would pay a bit less for your property taxes for your school, which is something that wasn't normally a thing if you were over the 65 or disabled homestead owner. This is just a brief image of what you can expect to see this upcoming November towards the end of the year once those tax bills start rolling out. And the main thing you want to look at whenever you're focusing on your property tax bill is going to be that bottom portion there, which shows what our coupon looks like. And our coupon is, for those of you who still mail in your payments or go into an office to make your payments, that is the section of your bill that you would bring in for us to scan and be able to accept your payment, and it would go straight to the property in which is being discussed on that bill, as opposed to, having to verbally or write down your property information and possibly, typos, miscommunication if you're speaking to someone in person, or even typing in something on your phone. And this way you can just go ahead and scan in your statement and then, make your payment, and it would bring up your information for you. Another visual here is for the differences between what you would pay without any exemptions, with a homestead, and then with a homestead and an over 65 or disability exemption. And, putting it in words is very different than seeing it in action as what it is without any exemptions versus what it is with a homestead, which, is the basic one for most of our homeowners. If you live and you occupy the property, that's something you're eligible for. And then our over 65 or disabled exemption really does show a pretty drastic difference from, paying a little over $7,000 a year to $5,000 or a little over $5,000 with just the homestead is a pretty drastic difference. And then, from that, paying $2,327, it takes a very large chunk, and people can really appreciate how much of a difference it makes in people's lives who are not able to make those whole payments or who have a more difficult time making those payments. And that's part of what the exemptions are there for, is so that they are able to assist in allowing for our over 65 homeowners and our disabled homeowners to keep their homes. So that's one of those allowances that the state wants to make sure that we have. Tax limitations. This is another excellent point for our over 65 and disabled exemption homeowners. This puts a limitation of the amount that you would pay for your school's property taxes, meaning that the amount that you pay the first year that you turn over 65 and have that exemption applied to your account, that puts a ceiling or a cap. And from that point forward, you would not pay more than that first year for your school. Meaning, first year you pay $500 for your school taxes for whatever the amount that your property was owed for that year. The next year, say your property value goes up, and instead of the calculations turning out 500, they turn out 7. Well, because you have that ceiling or that cap on there, that property value will continue to increase, but the amount that you pay for your school taxes will not. It will remain at that 500. Now, say for whatever reason, your property value or the amount that you would normally pay for your school taxes goes down. Instead of paying that 500 that you paid the first year you turned over 65, this year the calculations turn out 300. Well, it's a cap. It's not a freeze. It's not going to stay at that level. It's not going to stay at 500. You would instead pay the 300. So you can always pay less. You could always wind up paying on a bill for a lesser amount, but you will not surpass that 500 from the first year that you turned over 65. And that is another one of those allowances that the state has allowed us for to make sure that we are making it easier for our over 65 and disabled homeowners to stay in their homes. So really good boon for that. Another excellent, excellent option that I cannot press enough how imperative it is that you really look at and take this into consideration is the tax deferral. A lot of folks are scared because, the tax deferral, when you stop owning the property, when you pass away, when you sell, when you gift, whatever the situation may be, yes, the taxes that you did not pay to your property will be owed after you no longer own that property. However, if you are able to continue to make your payments, if you are still able to make all of your property tax payments timely, excellent. There is nothing saying that you cannot make your payments on time. And if it is something that you're able to continuously do, then, all the more power to you. However, the tax deferral works very similarly to an insurance on yourself, meaning that you're not required to use a tax deferral. You're not required to not make your payments or to wait or to, give yourself more time, but it allows you to have that additional leeway and that additional time to postpone your taxes, meaning that, say the absolute worst happens or the absolute best. You could be out on vacation, you forget that you have a bill and, you come back in March and you realize, oh my goodness, I didn't pay my tax bill. Well, this allows you, if you have the deferral active on your account, the deferral implements a 5% tax interest fee for the full year, as opposed to the 7% in February, 9% in March that you would normally get paying your taxes without the deferral. So if you're able to continuously make your payments, then, excellent, please continue to do so. But the worst thing that could happen is, if for whatever reason you're unable to pay your property taxes for that year, for whatever the reason may be, you have that insurance, because once a tax deferral is on your property, you wouldn't be taken into litigation. You won't be able to, it would prevent foreclosure. You would have only 5% interest per year. That's not every month. That's not an additional, accruing interest every month. That is per year. So while yes, if you do not pay your taxes over that time that you have the deferral, it is something that you could speak to your heirs about. This is something that you could speak to whomever you're expecting to receive that property once you either pass away or if you move or decide that you're no longer going to be in that property. It is something that you should speak to your heirs about and, let them know. They may want to start paying on your property taxes now, because I don't know about you guys, but I would much rather pay 5% per year than, an onward incurring penalty and interest fees for, however long it may take, plus, any additional attorney's fees or litigations. And, it just really is an excellent tool that, is available at your disposal. And honestly, if you continue to make your payments, then, the worst thing that happens is it's on a deferral and you don't really have to do anything about it. So it's not going to hurt you, but it can definitely help you. So qualifications for a tax deferral are going to be your homestead residents only, and over 65 or a disabled veteran. So all of these are options that you can go and apply for this deferral through the Harris Central Appraisal District. Now there is a note here. If you are still paying on a mortgage, then you'll want to speak to your bank or whoever your financing company is in reference to whether or not this is applicable to you. Mortgage companies will occasionally not allow for a deferral of property taxes, so you'll want to speak to them before you start incurring any of those. So make sure that they're aware and that you're aware of what you're able to do for your property. Aside from the deferral, we do also have flexible payment plans that are available, and this goes to all properties. This is not just for homeowners, not just for properties in which you live in. This is any type of property. We can offer anywhere from 12, 24, 36 months, and while you'll be given the terms of your property tax payments, you are always able to pay off early, meaning if you come into a sum of money, if you have the ability to pay more per month, by all means, go for it. You can finish it off early, pay with less penalty and interest, and, we're happy to do that for you. but it does help you to avoid collection efforts, foreclosure efforts, and you avoid attorney's fees so long as your payments or your payment plan is created prior to a law firm beginning their collections on the account. So highly recommend it. If you know come end of January you are not going to be able to pay the entirety of your tax bill, you know, please feel free to you know, set an alarm, set a timer for yourself. February 1st, February 2nd, give us a call. We'll set up a payment plan for you. We'll have your account set up that way so that you can have that peace of mind that even if you're not able to pay it off all at once, that you're able to continuously make those payments, and then so long as you're making those payments timely and continuing your efforts, then it would be paid off by the time of your payment agreement. Quarterly payment plan. This is another one of those benefits that we have for our over 65 and disabled consumers. This does have to be applied to a homestead for over 65, disabled owner, disabled veteran, or the surviving spouse of an over 65 or disabled veteran. This allows you to pay your property taxes in 4 equal installments as opposed to one lump sum come the end of January. And this is available without any kind of application process. You don't have to make any documentation for it. The only thing that you would be required to do is to continuously make these payments. So January 31st, you would come in and make your first quarterly payment, and then following payments would be due at the end of March, at the end of May, and at the end of July. And this allows you to pay with no penalty and interest so long as everything is paid timely. But it also allows you to have that additional time should that be necessary for you. And this is not one of those similar to deferral deals. You don't have any, you know, the only taxes that would be owed after this would be, you know, should you owe taxes past those dates, and then penalty and interest fees would accrue. A little bit more information on our general payment plans for both homestead and non-homesteaded properties. You know, the time periods that we're able to make these payment plans for is anywhere from 12, 24, 36 months. And you can see here the penalty and interest fees do change whether you have a homestead or not. If you have a homestead property, it is a 1% interest per month plus the initial penalty month, meaning if you start your payment plan in February, then you would have that 6% initial penalty, and then the interest would increase 1%, but the penalty would remain at that 6%. So as opposed to with non-homesteaded properties, which penalty and interest continue to accrue. However, all of that penalty and interest is taken into consideration when your taxes are calculated for that payment plan. So rest assured, so long as you continue to maintain your payments, you know, in a timely manner, and you make those timely payments, once that payment plan time is out, you will have been paid off in full. But, you know, please feel free to pay it off earlier. There is nothing wrong with that whatsoever. In fact, it would actually save you money because you would be paying less penalty and interest. We have multiple payment options. I showed you earlier a copy of our coupon, which is the ideal method if you're going to be sending this into us by mail, or if you're going to be coming into one of our office or one of our branch offices. We also accept payment online, which is a very handy tool because you're able to make this from the comfort of your home, of course. And we also accept payments by phone. So if you'd like to call our number there, you know, you can input your account information, and we would be able to accept payments that way as well. Please bear in mind, any payments made with cards do assess a convenience fee through the credit cards of 2.45%. However, we do have the option online for paying through e-check, which is free. There is no additional fee for paying with an e-check. And then, of course, we do accept cash in our branch offices, but we do not accept cash by mail. We have our contact information up here. Should you have any questions, should I have not covered anything, or if anything during this presentation reminded you of a query, or if anything you feel needs more explaining, you know, feel free to give us a call. Our number is listed on here, as well as our email address and our website, which is full of excellent information should you have any questions in reference to your property taxes. But in all, this is what we would urge you to do, is to constantly, be aware of what your situation is. If you have any questions, reach out. There is absolutely no shame in asking for clarification, no matter how many times it may be. And, I do urge you to write down this information so that if you do have questions later on, once your bill comes out, then of course you can contact us with any further questions that you might have. Do we have any questions by any chance? I'm not seeing anything in the chat right now, but in case.
Yes, I have a question.
Yes, ma'am.
The question is about exemption. Do you have, let's say, for example, this year I'm 65. Since your exemption is over 65, does that mean the following year when I'm 66, I'm eligible for that exemption?
So you can apply for the over 65 exemption starting this year. So you are able to apply for it the year you turn 65, and it would be applicable the year you turn 65, not the year after. So it's 65 and up, not past 65.
Okay. And the other question was about that exemption she talked about for the damages for the recent hurricane.
Yes, for the temporary exemptions, yes, ma'am.
The one that's 15%. Is that 15% of your appraised property damage, or is that 15% of the physical property damage? And how do you make that determination that it's 15%?
So that would probably be a better question for our company here with HCAD, since they are the office that makes that determination as to whether that applies or not. I'm not sure if either Ms. Manifee is on here still.
Yeah, I'm still on here, and
there we go.
It's physical damage to the property, and it doesn't include the land. It's just to the dwelling, and it's actually something that's decided by the appraisers. They come out and look at it. So,
who's the appraiser? Are you talking about the appraiser who does the appraising for the county? Or let's say, for example, I had somebody to come out to my home after the damage is done, and he looked at the property. He said, "Oh, you had damages to your roof because of my neighbor's tree," and then I obtained moisture damage. He said, "Well, you also have moisture in your wall." So, how do they make that assessment? Yes, it does meet the 15% damage.
So I think I showed on the slide, you'd want to submit when you file your application, your for the temporary disaster exemption. You can also include any papers from FEMA, from your insurance department, from your insurance company, that shows the percentage of damage or how much it's going to cost. And ultimately, that goes into the temporary disaster exemptions, slightly different from our regular exemptions, because those are things that are going to be looked at by appraisers and not our exemptions department to determine the level. But certainly, if you've got insurance papers and FEMA papers that meet that 15% threshold, it should not be a problem.
Okay, because I don't have, well, I didn't have insurance on my home, but I did have to pay out even though a FEMA person came out to look at the damages, I went ahead and hired another person, an adjuster, to come out to look at the home, because the assessment that FEMA does when they look at the damage is totally different. I had to hire a structural engineer to come look at the damages, versus when FEMA comes out, they look at the inside damage. What kind of damage has happened on the inside? What did you lose? They may look slightly at the outside. Oh, you had a few shingles missing, but it's not the same thing as when actual structural engineer comes out and look at your damages and does the assessment. So that's why I was wondering, okay, when he sent me the report of what he found, can he, and I'm not asking you, will I have to reach out to him to ask him, okay, what percentage would you determine happened to my home? Do I need to reach out to him, the person who came out and did the assessment?
No, ma'am, you can add, you can if you like to, if he's got information that you want to provide to HCAT. But what I would suggest is that you go ahead and fill out the form with HCAT, and if you want to send me your information, I can forward it on to our appraisal department, and the folks that'll actually do the determination in terms of whether it meets that 15% based on HCAT's valuations. So why don't you do that, and I can put you in touch with someone that can, the folks that actually do that.
Okay, and if you could some kind of way give me your information right now, I can't do it because I'm on the freeway and
Ah,
there's construction around me and 18-wheelers, and I'm
oh,
on my
no,
way
no,
to
no, no, no,
Oh,
no, no, no,
don't do that.
no, don't do it now.
and the speed limit is 75 miles.
No, 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 no. Did you register for this session, or are you on Facebook?
Yes, I did. I did register.
Okay, then why don't you just, we can actually get that information through your registration.
Okay, thank you very much. I appreciate it.
Oh, what's your name again?
My first name is Regina.
Regina. Okay, Miss Regina. Yeah, I'll get that information from NRCDC and get you
All
that.
right.
Okay,
Okay, thank you very much and stay blessed.
you're welcome. Thank you as well.
So aside from those questions, I don't have access to the Facebook. Are there any other comments or questions on there that we could be answering here?
No. Diana, is Diana there? I don't see any more in the chat either. Do you?
There's a
Not at this
question in the
moment.
chat asking about the presentations. Will that be available to us through email?
Yes, it will. Hi, Kimberly. Yes, it will be available.
Hello. How are you? Thank you so much. We appreciate that. I
Oh,
think Tony and I were wanting, and I'm sure others, we just want to have something to reference to just in case a question comes up and we can reference to the presentation that you all have already given to us.
and actually,
Yeah.
Neighborhood Center CDC will forward you those presentations.
Mhm.
Thank you.
You're welcome.
Absolutely.
Anyone else? So we're just about at 3 o'clock, and we want to stay timely and be respectful of everyone's time. So I don't see anyone else here. So I'm gonna go